Okay, we're back in session, so let's go.
Mr. Major, I'm gonna turn to you first. Mr. Major, briefly describe your background and experience.
Firstly, good morning. Good afternoon, Mr. Chairman, members of the Commission. I began my employment with the Office of Regulatory Staff as an auditor in 2009 and was promoted to audit manager in 2016.
Did ORS verify the operating revenue, operating expenses, and net operating income for return?
Yes, we did.
What were those amounts?
The company's total South Carolina retail operating revenue was $562,188,000. Operating expenses were $456,603,000, and net operating income for return was $105,585,000.
What was the total rate base?
The company's South Carolina retail rate base was $1,388,457,000.
Did ORS and the company agree on certain adjustments?
Yes, we did.
And what are the total number of adjustments referenced in your testimony?
41 total.
Of that 41, how many are currently in dispute?
Currently 14.
And that 14 is based on what is in your pre-filed testimony?
Yes, ma'am.
Okay. Can you identify the 14 adjustments in dispute in today's proceedings before the Commission?
Yes. Adjustment 17 to adjust for previously deferred amounts, that being the Harris COLA, Grid South, Fukushima cybersecurity, and the 2014 storm cost balance. Adjustment 18 to amortize deferred environmental costs. Adjustment 19 to amortize the deferred cost balance related to South Carolina AMI. Adjustment 20 to normalize storm costs. Adjustment 21 to annualize non-labor O&M costs. Adjustment 22 to normalize O&M labor costs. Adjustment 25 to amortize rate case costs. Adjustment 28 to adjust for credit card fees. Adjustment 29 to adjust for O&M executive compensation. Adjustment 30 to adjust for Customer Connect additional expense and deferral. Adjustment 35 to amortize deferred costs related to the South Carolina grid. Adjustment 36 to remove certain expenses. Adjustment 38 to adjust for an ongoing payment obligation. And finally, Adjustment 39 to adjust for nuclear supplies and materials.
Mr. Majors, are you aware that very recently the company and ORS have come to an agreement in principle but not executed on certain of those 14 adjustments?
Yes, ma'am.
Okay. What is ORS's position with regard to adjustments for inflation?
ORS's position with regard to adjustments for inflation is that they are not known and measurable. They are speculative and should not be used when setting utility rates. This is a position the ORS has taken in every rate case to my knowledge, and a position the Commission has upheld in the past.
To what did the company apply inflation adjustments?
The company applied inflation to Adjustment 20 to normalize storm costs and to Adjustment 21 to normalize non-labor O&M.
What is the amount in disagreement between ORS and the company regarding inflation adjustments?
With storm costs, the South Carolina retail allocated portion is approximately $101,000, and with the non-labor O&M, the amount is approximately $508,000.
What is ORS's position with regard to estimates for credit card fees?
ORS's position in regards to adjustments with estimates is that they're not known and measurable.
Has the Commission previously addressed estimates?
Yes, the Commission has addressed adjustments containing estimates in the past and has rejected them.
What is the amount in dispute between ORS and the company?
The amount in dispute is approximately $129,000 for Adjustment 28 credit card fees.
What is ORS's position with regard to Customer Connect?
ORS proposing an adjustment to include Customer Connect program costs through December 2018 actual expenses and to exclude the forecasted contingency costs included in the adjustment proposed by the company. ORS also does not propose to include the remaining balance of costs that may not be incurred by implementation of this program in a deferral.
What is Customer Connect?
Customer Connect is an interactive software communications program whereby customers get aids in billing and payments, power outage notifications, things of that nature.
What is ORS's position with regard to forecasted contingencies?
ORS's position is that forecasted contingencies contained within the company's adjustments are not known and measurable.
Has the Commission previously addressed forecasted contingencies?
Yes, the Commission has addressed adjustments containing forecasted contingencies and has rejected those as well.
What is the amount in dispute between ORS and the company regarding regarding the Customer Connect?
The amount in dispute for forecasted costs for inflation and contingency is approximately $550,000 for Adjustment 30, the Customer Connect program.
Did ORS recommend an adjustment to other O&M expenses?
Yes.
Are these non-allowables?
Yes, they are.
What does the term non-allowable mean?
Non-allowable is a general category of expenses that have been disallowed for rate-making purposes. They would include items such as alcohol, penalties and fines, lobbying fees, lobbyist costs, flowers, candy, image building, advertising, parties, charitable contributions, things of that nature.
What is the total amount in dispute for non-allowables?
As a result of the stipulation reached with the company, ORS proposes a non-allowable adjustment of approximately $568,000, of which $389,000 is related to litigation expenses discussed by ORS witness Ham.
Has the Commission previously addressed sales incentive awards, safety and length of service awards, miscellaneous gifts awards, and parties?
Yes, the Commission has addressed those items in previous rate cases and approved their disallowance for rate-making purposes.
Did ORS provide the company the opportunity to provide additional supporting documentation and detailed reasoning for why expenses should be allowed for recovery from customers?
Yes, the ORS provided the company opportunities to provide additional supporting documentation and detailed reasoning for their allowance.
What about dues for organizations?
ORS recommends that the Commission disallow dues for membership in non-professional organizations such as social clubs, Lions, Rotary, etc., things of that nature.
Has the Commission previously addressed how to treat dues for organizations?
Yes, the Commission has previously addressed dues for organizations and has rejected dues for non-professional organizations. Also, the Commission has ordered that only one-half of Chamber of Commerce dues and expenditures were allowed.
Are these Commission orders that predate 2005?
Yes, these Commission orders predate 2005.
What is ORS's position with regard to bonuses?
ORS's position with regards to bonuses is that customers should not pay for the entirety of the bonuses. Bonuses should be equally shared between the company and its customers. And a 50% share of bonuses fairly distributes costs between the company and its customers.
What is the amount of ORS's adjustment on bonuses?
ORS's adjustment for bonuses is a part of Adjustment 22. And in total, ORS proposes removing $4.172 million for these bonus plans.
Would you address some of the issues raised by company witness Bateman's testimony?
Yes, I would.
Did ORS provide the company to support the expenses referenced in Adjustment 36, which is entitled Remove Certain Expenses?
Yes, the ORS presented the company with a listing of transactions for which it intended to disallow for rate-making purposes and requested that the company provide additional supporting documentation and detailed reasoning as for why these expenses should be allowed and included for recovery from customers. The company responded with its own adjustment, Adjustment 36, to remove certain expenses in the amount of $97,000 and concluded that the remaining expenses should be allowable. While we may differ on a matter of perspective, our perspective is grounded with prior Commission order.
Thank you, Mr. Major. With that, I'll turn to Mr. Payne. Mr. Payne, please provide a brief overview of your testimony regarding deferrals at issue in this proceeding.
Good afternoon, Mr. Chairman and members of the Commission. The purpose of my direct testimony is to set forth the ORS recommendations related to 8 accounting deferrals that Duke Energy Progress proposes adjustments for in this docket. The purpose of my rebuttal testimony is to address certain issues raised in the company's rebuttal testimonies related to these 8 accounting deferrals. The primary issue the company addresses in regards to my direct testimony is the issue of a cost of capital return on its deferred expenses. My rebuttal testimony explains that the company is in fact not guaranteed a cost of capital return on its deferred costs, and that ultimately the issue of a cost of capital return is to be decided at the Commission's discretion. The company proposes the recovery of these deferrals through adjustments number 17, 18, 19, 30, and 35.
When you say a cost of capital return, does that include a return of equity component?
Yes, it does.
Can you describe the deferrals that the Commission has granted the company since its last rate case?
Since Duke Progress's last rate case, docket number 2016-227-E, the Commission, without objection from ORS, has granted the company 4 different accounting deferrals, which the company is seeking recovery of in this docket. Of these 4 accounting deferrals, 3 have been to recover costs associated with projects initiated by the company. These projects are the AMI meter rollout, the Customer Connect billing interface, and the company's grid mod initiative. The company has proposed deferral balances totaling little more than $5 million for these 3 accounting deferrals. The company's 4th deferral allows the company to defer costs associated with its cleanup of coal ash residuals at its retired and existing coal-fired generation plants. The company is seeking recovery of a proposed $50 million deferral balance to recover these costs.
Can you describe the deferrals that the company had been granted prior to their last rate case?
Yes, in addition to these 4 deferrals, the company has 4 deferrals that they did not seek to recover in their last rate case. These deferrals are the Harris COLA, Grid South, Fukushima Cybersecurity, and the 2014 storm cost deferrals. The company is not seeking to recover the 2014 storm cost deferral at this time. The company has proposed, as part of adjustment number 17, to remove the 2014 storm cost deferral balance from its rate base and pursue alternative recovery methods. The Grid South and Fukushima cybersecurity deferrals were included in the company's rate base as a result of the company's last rate case, and the Harris COLA deferral was not included in the company's rate base at that time, nor is the company requesting this deferral be included in rate base through this docket.
Can you please explain ORS's proposed treatment of the company's accounting deferrals?
Yes, in each of the company's deferrals granted since its last rate case, the company calculated a weighted average cost of capital return on its deferred costs. Additionally, the company proposed to include the unamortized balance of these deferrals in its rate base. ORS recommends all of the deferral balances be separated into 2 categories of costs: operating-related costs and capital-related costs. ORS recommends the recovery of both the operating-related costs and capital-related costs to be subject to the same regulatory accounting treatment required for each category absent an accounting deferral.
Does ORS's recommended treatment of the accounting deferrals support the public interest?
Yes, ORS's proposals represent a reasonable and equitable approach to the company's recovery of deferred costs. ORS's recommendations allow the company to recover costs that were largely incurred outside of the test year. In total, the company's ORS recommendations contribute approximately $3.5 million to the ORS proposed revenue increase of $32,130,000, which is slightly more than 10%.
Does the company recover a cost of capital return on operating and maintenance expenses incurred during the test year?
No, absent accounting deferral treatment, rates are set to permit the company an opportunity for recovery of its operating expenses, as well as the opportunity to earn a fair and reasonable return on its capital investments. Our position is simply that the company should not recover a return on deferred O&M expenses incurred outside of the test year when they would not have earned a return on those same O&M expenses had they been incurred during the test year. My rebuttal testimony primarily addresses the company's assertion that it is entitled to recover a cost of capital return on these deferred costs. The company's proposals include a cost of capital return from the time the deferrals began until the company has fully recovered the deferral balances through service rates. My rebuttal testimony explains that the company is in fact not guaranteed a cost of capital return on its deferred costs, and that ultimately the issue of a cost of capital return is to be decided at the Commission's discretion.
What is the dollar amount at issue related to the return on deferred costs?
Well, While the ORS's positions on the company's accounting deferrals have a substantial impact on the company's revenue requirement in this docket, the portion of that impact attributable to the issue of a return on deferred cost is approximately $900,000 of the total revenue requirement impact related to these 5 total adjustments of $3.5 million.
Were you able to observe company witness Bateman's testimony from the first day of the hearing?
Yes, I was.
Do you have a response to her summary?
One part that Ms. Bateman incorrectly testified that ORS relied upon other state commission actions when ORS made its recommendations on deferrals. That is incorrect, as ORS provided the information related to other state commissions to demonstrate there is no singular prescribed treatment for accounting deferrals, and that ultimately public utility commissions, including this commission, have a wide-ranging discretion in making those decisions.
Thank you, Mr. Chairman, Commissioners. The panel is available for cross-examination and commissioner questions.
Thank you. Okay, Mr. Neal. Mr. Guile. Thank you. Mr. Elliott.
Mr. Major, a wise man once said that the only incentive an employee needs is a paycheck. Would you agree?
Yes, sir, I would.
And notwithstanding that pearl of wisdom, it's the ORS position that the company ought to be able to recover 50% of its long-term and short-term employee bonus incentives, correct?
Yes, yes, sir.
And as I understand it, your policy, as you've articulated here today, is part of a long-standing ORS position on recovery of bonuses, correct?
Yes, sir.
And as I understand it, this commission has approved the ORS's position in prior rate cases. I know at least in one case over the objection of my client. Is that not the case?
Yes, that is the case.
All right. Mr. Payne. Hold that thought. No, I want to come back to you. You're not off the hook, Mr. Major. I think there is a dispute between the company and the ORS over the company growth projection with respect to its credit card usage. Is that correct?
I believe that item was part of the stipulation that was just introduced.
Okay, so y'all have resolved that issue? There was a dispute between ORS and the company on the historical growth and industry of the credit card.
The credit card fee, yes. But go ahead and ask your question. I mean, it's open cross. You're welcome to ask.
Well, I do want to ask, the company makes a nice point, and I'd like to press it just with a question or two.
Yes, sir.
Ms. Quick testified for the company on this issue, and as I understood the ORS position, I may have gone a little too far. That the ORS position is that forecasts are not known and measurable. Isn't that true?
Yes, that is true.
And if I understood the ORS position on projections, they are unreliable and not known and measurable, correct?
Correct.
Now, I want to, with respect to this issue, Ms. Quick testified in her summary, and I've got that on the Elmo. I won't read the whole thing in the interest of time, but the latter question is, I then go on to describe the company's process to forecast the growth projection based on historical data and industry research to demonstrate the reasonableness of the calculation. Have I read that correctly?
Yes, sir, you have.
And so basically what the company's doing here is they are compounding speculation with speculation. She is forecasting a projection, isn't she?
Yes, she is.
Thank you. Now, Mr. Payne. You are familiar with Ms. Hunsicker's testimony in this docket, are you not?
Yes.
And I believe Ms. Hunsicker submitted rebuttal testimony in response to your direct testimony, where she explained the company's calculation of incremental O&M expense for 2019 and 2020 and how it clearly met the known and measurable standard. Do you recall that?
Yes, I do.
And I'm looking at her summary, and I have it on the Elmo, and she testified, in response to witness Payne, I explained the company's calculation of incremental O&M expense for 2019 and 2020 clearly met the known and measurable standard because, one, the company has entered into fixed contracts with multiple vendors to develop the program. Two, the contracts contain provisions requiring the company to provide specified levels of internal labor to support the work. And three, fixed contracts contain specified price terms. I further explain the disciplined process the company used to forecast the expenses. Do you see that language?
Yes, I do.
Would you agree with me, Mr. Payne, that the only thing known and measurable about a forecast is that it will be wrong?
Fair assertion to make, yes, sir.
Now, with respect to deferrals, I'd like you to help me understand a little bit more about this because I find them complicated, and I think that they are complicated perhaps by design. Now, you testified to the number of deferrals that the company is requesting in this docket and how the ORS is contesting a handful of them, 5 of them or so, correct?
Yes, that's correct. I'm not sure of the 5. I believe it's 7.
All right, thank you. Now, I show you a copy of the petition by Duke in docket number 2013-472E. It is captioned in the matter of Duke Energy Progress, Inc.'s petition for accounting order for deferrals associated with Sutton, Fukushima, cybersecurity, Harris, COLA, and decommissioning. Have I read that correctly?
Yes, sir.
And I think the Commission issued order number 2014-138 in this docket that I've described, correct?
I believe so, yes.
And these deferrals are at issue. These deferrals, as outlined in the caption, are in controversy in this case, correct?
Some of them are, yes. The Fukushima cybersecurity and the Harris COLA.
All right. And if I may, in the petition seeking the deferral, at the foot of the page, and I've highlighted it, the company alleges the request for relief set forth herein will not involve a change to any of the company's retail rates or prices at this time, or require any change in any commission rule, regulation, or policy. In addition, the issuance of the requested accounting order will not prejudice the right of any party to address these issues in a subsequent general rate case proceeding. Accordingly, neither notice to the public at large nor a hearing is required regarding this petition. Have I read that correctly?
Yes, sir, you have.
And based on your study and review of the matters at issue in this docket, you understand that the Commission did not issue a notice to its ratepayers concerning this petition for an accounting order, did it?
I don't believe they did.
And you also know that there was no hearing held on this matter. The commission issued its order based on correspondence from the ORS and the application of the applicant here, correct?
That is my understanding, yes.
And in this, again, in the same docket, same petition, the company alleges that the accounting order granting relief DEP seeks in this petition will not preclude the Commission from addressing the reasonableness of the cost deferred in regulatory asset and liability accounts in the next general rate proceeding, correct?
Yes.
And the Commission approved the deferral request in this case, did it not?
Yes, every one of them.
And in fact, if I showed you all the petitions, and I won't do that in the interest of time, but if I showed you every petition for deferral in any of the contested matters, the caption would be similar in every case, correct?
Yes, as it relates to the deferral that would be specified in that petition, yes.
And there'd be language in every petition that says, in essence, there's really nothing to see here because we're just seeking an accounting order, and so you don't need to notice your customers and you don't need to have a hearing on the matter, correct?
Through what I read of the petitions, yes, that was the case.
And the applications also say, and anyway, we'll have a general rate case proceeding and we can solve all this at that time, correct?
Yes, and usually the orders would include language to that effect as well.
But now, I don't understand the company's position to be that these deferrals and the return on deferrals and the amortization on deferrals are fair game. I understand the company's position to be that to alter, at this point, to alter the deferral order will prejudice the company in some way financially. Isn't that basically their position?
They are definitely disputing our recommendation to not allow a cost of capital return. So yes, I would believe that is a true statement.
All right. Now, I want to show you, well, I want to ask you, you're familiar with order number 2019-214 issued by this commission on March 20, 2019, aren't you, sir?
Yes.
And in that order, the commission granted a motion that reads, for this reason and for the sake of transparency, Mr. Chairman, I move that if a filing made by an investor-owned public utility is filed with this commission, the heading or caption of the filing must include specific words that indicate specifically the type of adjustment or impact that the filing could potentially have on South Carolina ratepayers. So if the filing contains a request for an increase, decrease, or an adjustment of the company's rates or charges, or a new or deleted rate or charge, the heading and the caption on the filing must include these words or phrases. Have I read that correctly?
Yes, you have.
Now, understanding that that these petitions, I mean, they go back to 2013, were filed before this order was issued. Can we agree that, notwithstanding that, the petition captions are nowhere near transparent here, are they?
Not to the extent that they will eventually increase customer rates. No, they do not spell that out in the caption heading.
And they don't spell that out in the body.
Or in the body, no.
That's correct. And the good news, I suppose, for utilities that avail themselves of these petitions is that the customers really, without more, their customers wouldn't know the impact of a deferral order on rates, correct?
Most likely not.
In fact, with all due respect to all the accountants in the room or who have been here, it seems harmless enough. It's just an accounting matter, correct?
Reasonable, yes.
But the impact in this case is far from minor. I show you your table 1.1 on page 3 of your testimony and ask you if it's on the Elmo and ask you if you recognize it.
Yes, I do.
And as I understand your testimony, these petitions for deferral, which lack transparency and which have been issued without notice and a hearing, now contribute a $68.6 million issue in this case, correct?
Yes, as the company has proposed. Say that part again. I think I missed.
Well, no, I think you got it. I mean, if I understand your chart, the company's asking for a recovery of $68,668,000 as resulting from these deferrals. Is that correct?
The $68 million is the total revenue requirement. They requested the $18 million figure just above that. That is what they have requested for the 5 adjustments related to deferrals.
All right. So, and the ORS position is that the company should be entitled only to $3.5 million as opposed to the $18 million, correct?
Yes, that is the resulting revenue requirement that we calculated based on our position.
And if I understand these deferrals correctly, if the commission grants either your number or the company's number, they're going to get rate recovery going all the way back retroactively to, in the case of the petition I read to you, 2013, correct?
Yes, even the Grid South, I believe, was costs incurred in 2001 or 2002, but that would be as far back as it goes.
So as a consequence, we're litigating 18-year-old issues today.
Yes.
And certainly no party is prejudiced in this proceeding from challenging a 2001 cost amount, are they? No. Now, I think, again, just to conclude, at the heart of the dispute is, first, the company would like to recover these rates retroactively, but they want a return on the cost, correct?
Yes, that is what they proposed.
And the ORS disputes the entitlement to a return, correct?
A portion of it, yes. The portion that the O&M costs that they would not have earned a return on had they not been deferred cost.
And I guess that was going to be my second point. They're also requesting to recover O&M costs as if they were capital costs, correct?
More or less. I mean, they are regulatory assets, but yes, they are requesting to earn a return on their O&M expenses. And
ordinarily, in this rate case, for instance, the company's not entitled to return on their O&M that they incurred in the test year, are they?
No, the way the revenue requirement is calculated, they would not earn return on any of their O&M expenses.
And so their request it gives them some sort of special status, correct?
It does, yes.
On a matter that began without a hearing, without notice, and an opportunity to be heard.
That is correct.
No further question, Mr. Chairman. Thank you.
Thank you. Mr. Smith. Thank you. Company.
Just goes out.
Good afternoon. Mr. Major, I have some questions for you, please.
Yes, ma'am.
Let's see, let me back up. Were you here when Commissioner Irvin suggested that the company have closer relations with the Farm Bureau?
Yes, I was.
But based on your testimony, such as page 12 of your surrebuttal, the ORS wouldn't support the cost to join the Farm Bureau. Is that correct?
Based on my testimony, the ORS would not support the cost to, in regards to transaction with the Historic Marion Revitalization Association. I didn't mention Farm Bureau in my testimony.
Well, what's so different about the Farm Bureau or chambers of commerce or other community organizations where the company serves its customers?
Firstly, in title, that's an automatic difference. Also, our position is based on prior commission orders.
Okay. And we've talked a lot about, in your summaries and with other counsel, we've talked a lot about other commission orders. Is that correct?
Yes, ma'am.
And I understand you're not a lawyer, and I'm not going to ask you legal questions. But as to what those orders contain and whether the facts are the same, whether it's applicable to what the company's proposed, that will be something that will be handled, in your understanding, on briefs and in legal arguments. Is that correct?
Yes.
Okay.
I'm sorry to interrupt. I'm getting people in the back cannot hear Mr. Major. If Mr. Chairman, I don't think it's appropriate for me to instruct him, but I would let you know that I'm getting notice.
What she said, get close to that microphone.
Yes, sir.
And just to round that out, so if an order is on point or not to an ORS recommendation, that is something that you would expect to be handled in briefs, and we don't need to do that here today.
I wouldn't characterize it that way. Could you repeat it? Could you redirect that question? I don't understand your on point part.
Oh, yeah. There's been a number of statements about ORS has made certain adjustments based on prior commission orders.
Yes, ma'am.
And that is a statement that ORS has made, and the company may not agree with the applicability of those orders. Do you understand that?
I understand that.
And in order for the company to talk about whether these orders are applicable or inapplicable, that would be a legal argument of the type you'd see in brief.
I would suppose so.
Okay. And on page 4 of your surrebuttal, I'll let you get there.
Yes, ma'am.
If I understand your testimony correct around line 18, you say that LTI and STI, meaning long-term incentives and short-term incentives, removes the incentives for employees to achieve earnings goals through cost reduction measures. Is that your testimony?
No, ma'am. It is not. My testimony is that an increase in the company's earnings per share and total shareholder return due to an increase in the company's rates through a rate case with no actual improved company efficiency or operating performance results in those items that you mentioned.
So then you do believe that an earnings per share goal incentivizes the company to reduce costs?
I would not necessarily agree with that either.
Okay, I just want to make sure I understand your testimony.
Mm-hmm.
And so you say this, and by this you mean an increase in the company's EPS and TSR. And you're talking about if the company's has a rate increase to increase EPS and TSR. You say that somehow that removes the incentives for employees to achieve earnings through goals, through performance, customer satisfaction, efficiencies, and cost reduction measures.
Yes, ma'am. If that is there, if the measure is essentially EPS and TSR, they would not necessarily coincide. They could not necessarily coincide.
Okay. But there's lots of years where the company meets its earnings goals without a rate case. Is that correct?
I would not be able to qualify that.
Okay. Is it your position then that the company only meets its earnings goals when it has a rate case?
That is not my position.
Okay. So then is your position that the company can and the company's employees can affect earnings in between rate cases?
I would imagine so, yes, ma'am.
Okay. I wrote this one big, so hopefully we can all read it. So this is just a simple premise. Mm-hmm. When you get to earnings, you have sales less expenses, and that gives you earnings. Correct?
Yes, ma'am.
Okay. And so you understand that the company's employee, through putting downward pressure on expenses, can help the company achieve earnings.
Yes.
Okay, and by the same token, when the company puts employees put downward pressure on expenses, that also leads to lower rates than they would otherwise be. Isn't that correct?
That could be the case.
Okay.
Mr. Major, point toward the mic when you talk. I know you want to look at Ms. Edwards, but get into that microphone that way.
Yes, sir.
Speak up.
Mm-hmm. And there's been a lot of
Excuse me, sorry about that.
And there's been a lot of discussion in this case about executive compensation. Are you aware of that at the public hearings? And there have been a number of questions around Ms. Good's compensation, et cetera.
I'm vaguely aware.
Okay. And aside from executives, what is your understanding of how rank and file employees contribute to earnings and earnings per share?
I don't have the numbers in front of me, but I believe, I know that they do contribute to that. I don't have the numbers directly.
Okay. And so when a lineman restores power after a hurricane and gets the lights back on and meters ticking, that is both a benefit to customers and to earnings, is it not?
I would imagine so, but that is not our position. Our position is that a 50-50 split equitably distributes costs between the company and its customers.
Okay, and I'm just asking you about rank and file employees and how they contribute to earnings. I understand the ORS position.
Yes, ma'am.
Okay, and so just to ask that one more time, your position then is that, in response to the question that I just asked, that when a lineman helps get electricity back on, meters spinning, and power back on, that benefits both earnings and the customer, correct?
In our position, it would fairly distribute the cost between the company and its customers. So I don't know what else to tell you.
Okay.
Yes,
And so in that scenario, then, the cost of the lineman getting that power back on, you would say then should be split 50-50.
Yes, ma'am. We're not saying that the company, we're just simply saying that customers should not bear the entirety of the cost.
Okay. And if a lineman earned $10,000 and that was market competitive salary and 30% of his salary was based on incentive, so $3,000, you would say that he should not receive the full $10,000 salary because part of it benefited shareholders. Is that correct? Regardless if the action is the same.
If I may object, I don't think those numbers are realistic. I realize she may be trying to pose it as hypothetical, but we don't have any linemen or any other salaries to use in the evidence. So it's basically presuming facts not in evidence, and therefore it would be difficult to respond. Thank you.
Okay, let's.
Okay. I'll just want to give a couple of other examples here. If a customer service representative offers and obtains a payment arrangement for a struggling customer who's late with their bill, that's both a benefit to earnings and to customers, correct?
Yes, it would be, and our position would also distribute that equally amongst customers and the company.
Okay. And in that scenario, then there is compensation being paid to a customer service rep for providing service to a customer that you would say should be split in half, and the company shouldn't recover all of it.
The company, yes, I would.
Okay. Last one. If a plant engineer comes up with a process to save time and money without compromising safety, that would be a benefit to customers and contribute to earnings, would it not?
Yes, it would be, and also our position would still remain in that where the benefits both lie, both have an equal share.
Okay. And if both benefit, then their interests are not divergent. Is that correct?
In what way do you mean?
In the fact pattern that I just gave, the shareholder interest and customer interest are exactly the same.
I wouldn't be able to qualify those levels of interest. I'm not versed in that area.
Okay. And so I understand that you're not an HR professional. Is that correct?
Yes, ma'am. Certainly not.
Okay, sure. And I didn't mean that in any way. Just that's not your background. And so, did you ask for any wage studies of the company's employees or compensation studies?
No, we did not. We requested the totality of the LTI and STI bonus payments that were paid, and we made an adjustment to cut those in half.
Okay. And you just said the word bonus, and is it your understanding that it's Ms. Mettler? Were you here when Ms. Metzler testified?
I was not, but I did watch via live stream.
Okay. And did you hear her say that these incentives are not bonuses?
I heard her say that, but that's her opinion. My understanding is the bonus.
Okay. And that's her opinion as an HR professional?
That would be so.
Okay. And were you here when she described how the company finds an appropriate salary level through market surveys and then adjusts that compensation to pay a portion of it as an incentive? Were you here for that? Did you see that?
Via live stream, yes, ma'am. And again, I would point back to we're not disagreeing with the company's total compensation program package, things of that nature. We just feel like a fair and equitable allocation needs to exist.
And so it's not ORS's position that the company is paying too much money to its employees?
I'm not. I don't think so.
Okay. All right. And ORS's position is it doesn't like how the company is paying its compensation?
I wouldn't qualify it that way. I would qualify it just as my position has been laid out. Okay.
And were you listening to the ORS counsel's cross-examination of Mr. O'Donnell yesterday?
Vaguely.
Okay.
Yes, ma'am.
Okay. And did you hear the exchange where? Let me back up. Did Mr. O'Donnell, to your knowledge, provide any testimony on this issue? Any pre-filed testimony? Excuse me.
Oh, I'm not aware.
Okay. Thank you. And so did you also hear counsel ask Mr. O'Donnell about the North Carolina rate cases?
If so, I don't recall.
Okay. And I'd like this order has already been entered. I think it was entered with Mr. Whitliff's testimony, and this is the North Carolina order. It's been referred to a number of times in this proceeding. May I approach?
Yes, ma'am.
And the reason I wanted to ask you about this, Mr. Major, is when I heard the testimony yesterday, I thought there was some question about what was actually decided in the North Carolina case, and I thought it was important to clarify what the commission had decided.
Yes, ma'am.
And did you see I tabbed page 30?
Yes.
And would you agree with me there that it says, and I'm only reading it just for expediency, the stipulation provides that the company accept the public staff's proposed adjustment to executive compensation to remove 50% of the compensation for the 5 Duke Energy executives with the highest amount of compensation, and to remove 50% of the benefits associated with those 5 executives.
Yes, ma'am.
Okay. And then if I go on to the last sentence in the next paragraph, this agreement is reflected in Section 3Q of the stipulation, which provides that the company's employee incentives should be adjusted to remove the cost of the STIP plan. That's the short-term incentive. Is that correct? STIP. Based on the company's EPS for employees who qualify for the company's LTIP. Now, that's a lot of acronyms, but do you understand that that's talking about removing the short-term incentives that are based on the earnings per share for employees who qualify for the company's long-term incentive plan.
Yes.
Okay.
Here's my first time seeing this.
Okay, sure. And we're done with this order. I just wanted to clarify what had actually been decided. Were you here the other day when Ms. Metzler walked through this chart?
I was not, but I've watched via live.
Okay, and have you seen this chart before?
Yes, ma'am.
Okay, and I understand that the numbers are a little difficult to read. It sure is difficult for me to read. But when I look at who gets long-term incentives and who gets short-term incentives, we have in the long-term incentive bucket the CEO and the ELT, executive leadership team, that's 99 employees, and then retention is 547 employees. Do you see that?
Yes, ma'am.
And it's my understanding that the ORS has taken issue with the retention column as well. Is that correct?
Yes.
Okay. And
Make sure
and then
you're
you
getting
would.
that microphone, Mr. Major.
I'm sorry.
I know you get looking back and forth, but they can't hear you on live stream, and you're just not going worldwide. And
And then
make sure everybody hears you.
And then under the short-term incentive, you'll see the CEO and ELT again, that's 99 employees. And then you'll see all the other 29,144 employees who will either allocate all or part of their time to Duke Energy. Do you see that?
Yes, ma'am.
And so it's ORS's position that every employee in the company who has this type of incentive, that 50% of that should be disallowed, correct?
Yes, right there on your chart. You see where it begins with the 8,000,003, and ours reduces it to 4,000,001.
Sure.
172.
Sure. And then understanding that there's an exchange with Mr. O'Donnell about what the North Carolina Commission decided, is it your understanding, based on that exchange in this chart, that applying that equivalent to South Carolina would be this number, a long-term incentive for the CEO and ELT, this number for retention, and this number for short-term incentives for the CEO and ELT?
Again, I was not quite. I'm not versed in the conversation that you had with Mr. O'Donnell related to this.
Okay. And is it your understanding then in North Carolina, what was effectively excluded from rates was not the portion of compensation that is incentive based for the 29,144 employees?
Mr. Chairman, I have held back. I don't believe Mr. Majors is familiar with the North Carolina. I mean, he can try and answer if he can, but he's not. He's clearly not familiar with the North Carolina order. I mean, he can try and answer if he can, and I have held back, but he's not familiar with the order, and he obviously was not familiar with the exchange with Kevin O'Donnell from yesterday. May
I briefly respond? So yesterday, ORS counsel asked a witness who had not offered testimony, pre-filed testimony on this issue, a series of questions. And if Mr. Major, he can't answer, then that's okay. If he doesn't know it, he can say, I don't know. But I would like to ask the only witness in this case who's offered pre-filed testimony on this topic questions. And if he doesn't know, he doesn't know.
You can answer, and if you don't know,
And I
let us
don't.
know.
Okay.
Yes, ma'am.
All right. Thank you. That brings that to a close. Mr. Payne.
How are you?
I'm good. How are you?
Doing well.
And there were a number of questions earlier around items that the company has now reached a stipulation on. So, for example, and if Mr. Major, if you have an opinion on this, please let me know as well.
Yes, ma'am.
But things like the credit card adjustment, storm, et cetera, there were questions around ORS's position that did not necessarily take into effect, understandably so, the stipulation that the company and ORS is working on. Is that correct?
Yes, I believe so.
And so is it your understanding that the company and ORS are working on a series of stipulations to numbers, but neither party is necessarily giving up their philosophical position?
Generally, yes, that's my understanding.
Okay, all right. And on page 4 of your rebuttal testimony, you cite adjustments 17, 18, 19, 30, and 35. Those are the deferrals, correct?
Yes, those are the ones I'm filed testimony to address.
Okay. Can you see that okay?
Let me get my glasses.
Okay.
Okay. Yes.
And so, so these are all the docket numbers for those deferrals. Is that correct?
Yes.
Okay. And just mechanically, I know the commission does not have to take judicial notice of its own orders, but I would like to ask that the commission take judicial notice of the filings in those dockets.
Yes, we will.
Okay. And a few minutes ago, Mr. Elliott was asking you, or the two of you, a series of questions around notice for these deferrals. Do you recall that?
Yes.
Is it your understanding, or do you have any reason to believe that those applications were not lawfully sought and lawfully ordered?
I have no reason to dispute that, no.
Okay, thank you. And for a few of these deferrals, they were actually part of the company's publicly noticed or discussed in the company's publicly noticed last rate case. Is that correct?
Yes, I believe the Fukushima and cybersecurity, and Harris and cybersecurity, I believe.
Okay, thank you. And as to the position for deferrals in this docket, ORS's position is a relatively new one. Is that correct?
That's fair to say, yes.
Okay. And if I look back over time in these dockets, I won't find language in those dockets like the ORS included in its surrebuttal testimony.
Typically, we file a letter of no objection to the time that deferrals are granted. We don't, to my knowledge, we haven't taken issue with deferrals. At the time that the companies request them, we reserve the right to discuss the recovery of the deferrals in the next general rate case proceeding.
Okay. And so do you see that docket 2016-227E?
Yes, that would be the last DEP rate case docket.
Okay. And there were deferrals came up in that rate case. Is that correct?
Yes, there were, I don't know the number, but there were several that the company had. My understanding is DEP had gone 28 or 29 years without a rate case and had a large number of deferrals, and I guess decided on their own to seek recovery of a portion of them and defer recovery of the rest of them until the next rate case, which would be this docket.
Okay. And do you recall the rationale for not seeking recovery of those deferrals?
I believe it was to mitigate the rate impact on customers.
Okay, sure. And certainly, I'll skip that one. Okay. And when I look at the accounting references, well, let me back up. And in that rate case, 2016-227E, in that docket, the ORS's current position, and a lot's changed since then, but ORS's current position was not articulated in that docket. Is that correct?
No, not the position we have stated here. But as you do state, we have had a change in our mission as an agency. I believe that's a big part of the change in our position from that docket to this docket.
Okay. And so when I look at the accounting references in your testimony, none of them speak directly to the ORS position in this docket. Is that correct?
And are you referring to the 2016 docket?
No, in this case.
You have to repeat that.
None of the accounting citations that you reference in your testimony speak directly to the position that ORS has taken in this docket.
No, the accounting standards that we cited in the docket do not do not form the basis of our recommendation.
Okay. And notwithstanding those references, that's a policy recommendation the ORS can make, period.
Yes, the policy is a departure from the accounting standards, I guess would be a fair characterization.
Okay. And as you stated, the policy and pros and cons of that policy is up for the commission to decide.
Yes, we make recommendations just as the company makes its proposals, but ultimately the commission makes the decisions.
Okay. And the other states that you mentioned on pages 25 and 26 of your testimony, and there's no citations there. That's just information that the ORS gathered.
Yes, I'm not sure yes.
Okay. And I'm sorry, I'm trying to go a little quickly, so if I'm going too quickly, I'm trying to save us both from turning pages. So if I'm moving too fast, let me know. And so there could be other cases out there. There's certainly other commissions have grappled with this issue.
Certainly there are, yes.
And whether commissions have grappled with this issue and to the extent could depend upon whether they had a forward test year, riders, other regulatory mechanisms.
There's a lot of outside circumstances that would influence other states and how they, handle. Yes, some states would have a better set of guidelines on the books in terms of granting deferrals in the first place. Others would, as you state, have other rate-setting mechanisms in place.
Okay. And on page 11, you referenced the NARUC rate case and audit manual.
I believe so, yes.
Okay. And just for the record, what is NARUC?
NARUC's the National Association of Rate Utility Commissions, I believe. They're basically an organization that it's kind of hard to. They give classes and they bring commissions and staffs and companies together and just basically discuss rate making issues and try to provide guidance as they can.
Okay, and are NARUC materials regularly sought and relied on in these types of proceedings?
Yes.
And have you ever seen, or does your agency use the NARUC electric utility cost allocation manual?
I would imagine so, yes.
Okay, may I approach?
Thank you.
Mr. Chairman, I would ask that this item be given judicial notice. I believe that's allowed under Rule 103-846 in regards to technical application.
And what is it?
This is the NARUC electric utility cost allocation manual.
Okay.
I'll show the cover page.
Okay.
And this manual was also discussed by Witness Barnes, Witness Hager. It's been referenced in this docket, so I just wanted to show the cover page here.
Counsel, is that the most recent edition available?
They have issued, it is the most recent that I'm aware of, and that's been referred to in this case. There have been a couple of smaller publications related to like distributed energy. And Mr. Payne, if you go to page 24 of this NARUC manual, do you see that paragraph highlighted in yellow? I highlighted it in yours as well.
Yes, I do.
And so, can you? Do you mind reading that for me?
Yeah. A utility, in order to remain viable, must be given the opportunity to recover its prudently incurred total cost of providing electric service to its various classes of customers. Cost of service is usually defined to include all of the utility's operating expenses plus a reasonable return on its investment devoted to the service of the rate-paying public. Accordingly, it is incumbent on the utility to ensure that the rates it charges for electric services are sufficient to recover its total costs. The total theoretical revenues a utility is authorized to collect through its rates for its various types of service is called the total revenue requirement or the total cost of service.
Okay, thank you. I'd also like to ask you about your statement on page 4 related to operating related cost and capital related cost.
Okay, give me just a second. Is that my surrebuttal or direct?
Surrebuttal.
Okay.
And so, do you mind explaining that a little bit more for us? What do you mean by operating related cost and capital related cost?
Yes, I think probably the best way to explain it would be to turn to Mr. Kelvin Major's Exhibit KLM1, if you have that available. It could be direct or surrebuttal. I'll go to direct.
Why don't you paraphrase it for me, if you don't mind?
So basically, if you look at KLM1, you have a line about in the center of the page there that is the total operating income for return, or I'm sorry, the net operating income for return. And essentially, the way we categorize things was anything above that line is O&M, and anything below that line is rate base.
Okay. And so what kinds of expenses would O&M expenses be?
Generally, every expense is not a capital asset expenditure.
Things like call center costs.
Yes, call center costs. I mean, imagine the point you're getting to with depreciation, income taxes, purchase power. A lot of things would go into that category.
Okay. And when I think about the costs that were requested for deferral, do you know of any operating related cost in the Customer Connect balance that would exist but for the capital being deployed for the program?
My understanding, I will say my initial reaction was that Customer Connect was a capital expenditure. However, your company's own testimony referred to those costs as incremental O&M, and therefore that is the position that we took, that they are incremental O&M.
Okay. And did you ask about what kinds of things that incremental O&M went to? What kinds of tasks those costs were for?
No, but I generally understood it to be the development of a new software system.
Okay. And so those costs to develop, those O&M costs to develop the new software system would not exist without the capital costs related to the software system.
That is fair to say.
Okay. And so then this commission could view that as a capital related cost for purposes of deferrals.
If it's going to be charged to your rate base, then yes, and if not, then no.
Okay. And thank you. And so when I think about AMI, would the company have any O&M expenses in this AMI bucket but for the deployment of the capitalized technology?
There's a distinction to be made here that you have the capital assets themselves that are the AMI meters, and they go into rate base. The company earns a return on those capital expenditures through the rates as allowed by the commission. However, there are O&M costs associated with operating those meters, as there are with pretty much all O&M costs are related to some function. You have basically all of your assets have maintenance costs that arise from them. So if you're trying to draw the connection between the capital costs that are in the rate base and the O&M, yes, there is a connection there. However, the O&M expenses as they are booked to O&M accounts, you do not earn a return on those expenses.
Right, and I understand that. But again, you told me earlier that deferrals are a matter of policy for the commission to decide.
Yes.
And this commission could decide that where you have O&M that's related to a capital asset, it could come to a different conclusion than the ORS.
They could, and I believe in this respect it would kind of go against it would go against what the typical accounting treatment is. Deferrals are a kind of a special bucket of expenses, though. So, yes, they would have that discretion to make that decision.
Okay. And in some ways, that wouldn't be dissimilar to other deferrals that have been recovered in rates for the company in years past.
That's fair to say.
Okay. And then on page 5 of your surrebuttal, you point to rates being designed to recover operating costs from the last case. I'll let you get to page 5 if you need to.
Which portion were you referring to again?
I'm sorry, could you give that reference again?
Sure. Page 5 of surrebuttal, lines 8 and 9, where you're talking about rates from the last case being designed to allow recovery of the company's operating costs?
Yes, ma'am.
And so when you think about these operating costs, AMI did not exist at the time of the company's last rate case, did it?
I'm not sure if they did or did not. But
Okay, but for the company, the deferral the company requested for AMI came in 2018, correct?
yes, that's fair.
Okay. And Customer Connect was not a program that existed at the time of the last rate case, correct?
Yes, that is correct.
Okay, and so those costs were not in the operating revenues that were established by this commission following that last case.
They would not have been included through the rate case, no.
Okay. And so the revenues that came out of that last rate case are not addressing those costs, which is why the company sought recovery, or sought deferral, excuse me.
They would not have specifically been designed to recover those costs, no.
Okay, thank you.
You're welcome.
For efficiency of the hearing, if it's all right, I'll leave my pack of stuff at the podium and collect it later. May I have the next hearing exhibit number?
66.
Okay. I'd like to mark it as hearing exhibit 66 and enter it into evidence, please.
Mark and enter it as Exhibit 66.
Thank you.
Okay, we're at Commissioner questions. Commissioners, any questions for this panel? Okay. Redirect. How much?
Very brief.
Like 3 minutes?
I might make it 5. Is that okay? Can I negotiate just a little?
Okay, we can go 5.
All right. Just very quickly, Mr. Majors, regarding the bonus item, it came out that you are not familiar with the North Carolina order, the most recent North Carolina order for DEP.
No, I'm not. This is my first time seeing anything related to it.
Okay, but given that the council did show it to you, if in fact there was a settlement or stipulation, you would have no knowledge as to what that compromise or what was negotiated between the public staff of North Carolina and other stipulating parties.
Not at all.
Okay. When ORS does a compromise or stipulation, there's usually is there give and take?
Yes, there is.
Okay. So is it possible that there was give and take in this stipulation or settlement in North Carolina?
Yes, I would assume so.
Okay. All right. Again, very quickly. Does ORS contest the company paying its employees the bonuses?
Not at all.
Okay. Okay. With regard to Mr. Payne, Mr. Payne, do you still have that NARUC document that was handed to you?
Yes, ma'am, I do.
Okay. Could you turn to that? Are you there?
To the page that I looked at earlier.
Do you see that the word?
In front of that microphone.
All right. Do you see the word total is underlined?
Yes, I see that.
Okay. Did ORS contest the cost of the capital expenditures or O&M expenditures as part of the deferral?
No, we only contest, well, with the exception of the coal ash cost, the only thing that we took issue with was the cost of capital return on those expenses.
Okay. The only thing ORS contesting here is the return on O&M?
Again, no, we have the coal ash disallowance proposed by ORS witness Whitliff. We also have some change to amortization periods which have an effect, but The main issue we've addressed is a cost capital return, yes.
There was a comment made about deferrals in the past. Has ORS had several settlement agreements with the utility companies?
For my understanding, the last 10 to 15 years, almost everything has been settled. The major cases, at least the big cases.
Okay. But notwithstanding that, have the companies always received a return on deferrals? Have they always received a return on deferrals?
No, not all companies, not all deferrals. Some companies don't even request returns on their deferrals when they bring them forth. It really is a case-by-case basis.
Okay. Thank you. I don't know if you timed me, but I think I was close.
You're close. Close. Recross. Okay. Thank you. Okay. Thank you, gentlemen, for your testimony, and you may step down and be excused. And we will continue this hearing tomorrow morning at 10 o'clock.